Well, good afternoon. Welcome to the National Archives Know Your Records program. My name is Andrea Bassing-Matney, and we are broadcasting live from the Washington, D.C. National Archives building with an on-site audience. Welcome to all of you here. We're so glad that you've joined us. Before we get started, I have a few tips I'd like to share with you so you know how to participate in this live broadcast, because we are broadcasting live on YouTube. So for our on-site audience, you can ask questions at the end of the presentation. We just ask that you use those microphones in the aisles so that we can capture your voice for our online audience. And for those of you who are watching online, you can also participate and ask questions by first logging into the chat section on this YouTube webpage, and we will take your questions at the end of the presentation. Also on this webpage, you will find that there are several hyperlinks. They will take you to the presentation slides and the 3 handouts. We also have live captioning available. So if you are watching this video as a recording, please know that all of these presentation materials will remain available online. For today's program, Damani Davis will discuss petitions filed by owners and slaves under the DC Emancipation Act that freed enslaved persons in the District of Columbia in 1862. Mr. Damani Davis is a reference archivist at the National Archives Research Services Division in Washington, D.C. Since 2005, Damani has lectured at local, regional, and national genealogical conferences where he focuses on the African American presence in federal records. He has published articles in the National Archives Quarterly Journal, Prologue. There he highlights African American participation in the Revolutionary War, African American migration and search for land ownership in the post-Reconstruction era, slavery, emancipation in Washington, D.C., today's topic, and early 20th century federal citizenship records of blacks in the British West Indies. A native of Philadelphia, Pennsylvania, and a veteran of the First Gulf War, Damani pursued his undergraduate studies at Coppin State University in Baltimore, Maryland, where he received his BA in history in 1998. He further pursued his studies in Ohio State University, where he received his MA in history in 2001. And now for our presentation, DC Emancipation Act. Ladies and gentlemen, please join me in welcoming our presenter, Damani Davis.
Thank you, Andrea. Thanks for coming out today and welcome to the National Archives. Today, I'm going to focus on records that we have here that document the April 16th, 1862 DC Emancipation Act. Although that's going to be the focus, especially the records of the Board of Commissioners that administered that particular act, I'm also going to focus on other records that we have here from the DC Circuit Courts that relate to slavery prior to the DC Emancipation Act. Okay. Sorry. Now, just to give a little historical background of Washington, D.C. and its role in slavery, during the time period leading up to the Civil War, D.C. served as a major center for what at that time was considered the domestic slave trade. Most scholars and genealogists who study the time period of the Civil War are very familiar with the rise of cotton throughout the newer states of the Deep South. But prior to the rise of King Cotton, tobacco reigned in what's now considered, or what at that time was considered the Chesapeake region, the states of Maryland and Virginia. And this tobacco cultivation was actually the oldest and more established type of slavery that existed prior to the rise of cotton. Thinking about Washington, D.C., as the nation's capital at this time, just the reality of slavery in Washington, D.C., and the sight of large slave coffles going through the streets of Washington, D.C., provoked outrage in certain quarters, primarily the early abolitionist movement. So there was a lot of advocates against the role of Washington, D.C. as a major depot of the domestic slave trade. Even here at the National Archives, we have some records or abolitionist records within our legislative records, if any are interested in some of those records. But with the rise of the abolitionist movement and a transition within the type of the decline of tobacco as a major cash crop in the ascendancy of cotton, slavery is going to decline in Washington, D.C. But despite this decline, the status of the enslaved population and even free blacks in Washington, D.C. is going to be very precarious. They're going to be a very vulnerable population because many of the enslaved population feared being sold further south into the cotton belt because of the high demand for enslaved labor in many of those states. And even many of the free blacks in Washington, D.C. were very vulnerable because at all times a free black would need to have his or her free papers or certificates of freedom on their person. If not, the person could potentially be jailed, and if the free black could not prove his or her free status in time, he or she would risk being sold further south also, even if it was a free person. And I'll go into some of the records that we have that demonstrate that vulnerability. Okay. But first, I'm going to introduce you to some of the records that we're going to focus on today. Here's a copy of the District of Columbia Emancipation Act, April 16, 1862. And within your handouts, I think I included a transcript of this act so that you can read it yourselves, or there should be a link on the web page. Okay. Now, under the terms of the original DC Emancipation Act, it legislated the immediate emancipation of all those who were enslaved within the District of Columbia, along with compensation to former slaveholders who could prove that they had remained loyal to the Union during the Civil War. The compensation offered was offered up to $300, even if the petitioners argued that their formerly enslaved person was worth more than $300. That $300 was the maximum that the government offered for each slave. The act also required that all owners claiming compensation file schedules listing the names of each enslaved person and just given a physical description of each enslaved person. And they had to submit those petitions by July 15, 1865. A supplemental act of July 12, 1862 was established, which permitted the submission of schedules by slaves or enslaved persons whose owners lived outside of the District of Columbia, if the slave had been employed with the owner's consent in the District of Columbia anytime after April 16, 1862. And what this reflects is the reality that, especially in this region at the time, many enslaved persons were actually skilled workers. And it was a common practice for some slaveholders to rent out their enslaved persons, meaning the enslaved person would work as an independent individual, but the owner would get money or get compensation for some of that work, and the enslaved person would also get a percentage. Okay. So those who were in that status, meaning they were hired out here within the District of Columbia, but the owner may have been from Virginia or one of the counties in Maryland. If that enslaved person was working or hire out within the District of Columbia during the time of the DC Emancipation Act, that enslaved person could apply for or petition for free status. And remember, at this time, the Emancipation Proclamation hasn't been established yet, and no one knows what the final outcome of the Civil War is going to be. So many of these enslaved persons had a major incentive to try to get their free status certified and documented. Okay. Now, is a short description of some of the main records that I'm going to focus on. The records of the Board of Commissioners for the Emancipation of Slaves in regards to the DC Emancipation Act. We have these records here on microfilm. The publication is microfilm 520, Records of the Board of Commissioners for the Emancipation of Slaves in the District of Columbia, 1862, 1863. Related records that we have pertaining to the enslaved population or documents generated regarding the enslaved population prior to the act are from the U.S. Circuit Court for the District of Columbia. And those are on two separate microfilm publications. The first, publication M433, Records of the U.S. Circuit Court for the District of Columbia relating to slaves from 1851 to 1863, and publication M434, Habeas Corpus case records of the U.S. Circuit Court for the District of Columbia, 1820 to 1863. So these records go even further back. And habeas corpus records, as it pertains to slavery, much of it, some of it relates to slaves who were fugitives, who had escaped and were captured. Some of it refers to free blacks who were being detained, and they were working, so they filed a writ of habeas corpus to prove that they were being illegally detained. And I will show you some examples of those types of cases. Okay, 520, here's just, again, the Board of Commissioners and some related records that we have here. There's a serial set within our congressional records that relate to these particular records. If someone is interested in going to a deeper historical study of some of the matters involved with the passing of this act, you can find this in some of our congressional records. And Dorothy S. Provine has compiled transcripts of many of these records in a publication called Compensated Emancipation in the District of Columbia Petitions under the file of April 16, 1862. Okay, now let's get into some of the examples of some of these documents. Here's an example of a petition that would have been submitted to the Board of Commissioners, okay? In this particular petition, we have the slave holder who signs at the top, Clark Mills of Washington County, DC. Within the petition, he names each of the enslaved persons that he owned up to that point. And since I don't have it transcribed here, I'll read some of the names for you. Here it says, Letty Howard and Tilly was bought from Peter Havener some 8 or 9 years ago. The rest of the children were born since. Levi Thomas and his wife Rachel Thomas were purchased in Baltimore about the same time. And Ross was acquired by his wife, referring to the Clark Mills' wife, the slaveholder's wife. Philip Reed was purchased in Charleston, South Carolina, many years ago when he was quite a youth. He bought him here, he bought him because of his evident talent for the business in which Clark Mills was engaged, and paid $1,200 for him. Now, for anyone familiar with Philip Reed, is anyone in the audience familiar with this individual, Philip Reed? Yes, oh, well, I forgot you don't have a mic there. Well, Philip Reed is the enslaved person that was involved with the casting of the Statue of Liberty, the Statue of Freedom that sits on top of the U.S. Capitol. So he obviously was a very skilled worker, and his former owner, Clark Mills, kind of alludes to that within the petition, where he says he referred to his Philip Reed's evident talent, really trying to highlight how valuable this person was. And again, since many of these slaveholders are seeking compensation, even though under the terms of the act, the maximum was going to be $300, there were still rumors and perceptions amongst many that they were going to be fully compensated at the full value of what the person argued that the enslaved person was held, or the value of that particular enslaved person. So oftentimes within a lot of these petitions, you will see a lot of detailed description of these slaves, highlighting their talents and so forth. I guess, or it seems to be with the idea that potentially there will be a greater compensation if the value of the slave is described very vividly. Okay. Okay. And this is just the second page where on this particular petition, it goes into more detail of each person and gives the monetary value of each person. Now, in the case of Philip Reed down at the bottom, even though he says he bought Philip Reed for $1,200, he considers Philip Reed to be valued at $1,500 at this time. Okay. And here's the secondary source or compensated emancipation in the District of Columbia that you can refer to that has a lot of these particular records transcribed. It just makes it easier rather than going through all of the microfilm. And also, I think Fold 3 has many of these records online now, the genealogical site Fold 3. Okay, going into some of the other records, emancipation papers, manumission papers, and affidavits of freedom, fugitive slave case papers, and so forth from the Circuit Court of DC. Emancipation papers refer to the certificates of freedom that were given after or as a result of the formal DC Emancipation Act. Now, manumission papers and affidavits of freedom, many of these were submitted prior to the DC Emancipation Act. Now, manumission refers to slaveholders who voluntarily freed their slaves prior to the act. So we have some of those records that may be of use. And then there are fugitive slave case papers also within these records. Under the Fugitive Slave Act, if an individual was accused of being a runaway slave or an escaped slave, and the former slaveholder filed a case in regards to that, those records will be in the DC Circuit Court. And this doesn't just apply to slaveholders who were from Washington, D.C. Oftentimes, the surrounding counties of Maryland and Virginia, also slaveholders from those areas also submitted here within Washington, D.C. because the Circuit Court in D.C. was the closest court of record that they would go to. And again, with those records, we'll view some examples. Okay, here's some of the basic documentation of a slaveholder's slave schedule that you will see in some of these records. Here's Columbus Alexander, similar to the prior one from Clark Mills that we saw. Here, Columbus Alexander lists the names of each of his enslaved property, their ages, their genders, and gives a physical description of each one. He lists Beverly Davis, 25, who's a male, and gives a physical description, black, medium size, and so forth, and Nancy Holmes, and gives the ages and descriptions of each of these individuals. So this is a typical schedule that you will see in most of the records. Here's another one of a Robert R. Aylmer from Washington, D.C. This person only had one enslaved person. So we see that the amount of slaves that a slaveholder had during this time would vary from person to person. Robert R. Aylmer only has this particular enslaved woman of 20 years of age named Margaret Watkins. And the physical description that he gives of her, he just says, Margaret is of copper complexion, of stout stature, about 5 feet inches, 5 feet inches, well, 5 feet tall, and of a pleasing countenance. Examples of basic emancipation papers. Here's one for Philip Meredith, which is a manumission filed June 30th, 1862. These emancipations filed on June 30th refer to enslaved persons whose owners may have lived outside of Washington, D.C., and who had failed to submit a schedule. So the enslaved person at this point could take it upon him or herself to go to the Board of Commissioners and submit a claim stating that he or she was hired out in Washington, D.C., the former master hadn't filed a claim giving him or her their freedom. Therefore, the enslaved person is taking it upon him or herself to do that. And again, they have a major incentive to try to get their freedom documented because no one knows whether they will have another chance to do that, depending on what the final result of the Civil War would be at this point. Now, the interesting thing of Philip Meredith, from his particular record when I went through it, was that he claimed to be a former slave of General Robert Lee. He says, and stating who his owner was, he states, General Robert Lee of Virginia, late of Arlington Heights, having claim of the labor or service of the undersigned, and having refused or neglected to file in your office, this petitioner further states that the undersigned has resided in said district for 22 years, and since the 16th day of April 1862, by and with the consent of said Robert Lee. Philip Meredith is described as age 30, dark copper color, and about 5'6". So evidently, General Robert Lee is very occupied at this point. He might have, this person, Philip Meredith, may have been hired out. He may have been a skilled worker and had been working many years within the District of Columbia, and a portion of his earnings would have gone to the household of his owner. But at the time of the DC Emancipation Act, since he was residing in Washington, D.C., and his owner, Robert Lee, had never submitted any type of claim for him, obviously, Philip Meredith has taken it upon himself to submit his own claim to have his free status under the terms of the DC Emancipation Act recognized. Okay. Here's the case of a family in Washington, D.C. who, again, under the terms of the July 12th Supplemental Act, meaning the owners of this family had failed to submit a claim for them by the deadline, this family is seeking to have their freedom recognized. And they actually were accompanied by their former owners, okay? And it reads, the claimants of the within named servants appear before the commissioners with the servants for evaluation, and that a report may be made to Congress for compensation, for which they have petitioned, and the servants are now in the District of Columbia by consent of said claimants, who ask that their free papers be filed them, to which they are entitled under the Act of 12th July, 1862. Okay. Within this particular petition, again, the same type of detailed physical description of gender, age, and so forth is given for the Addison family. Of course, there's Alice Addison, age 55, brown colored, 5'4", healthy and strong. Rachel Addison, Alice's daughter, age 24, brown colored, 5'8", healthy and strong. Marianne Addison, Alice's daughter, age 26, brown, 5'6", heavy built, healthy. George Addison, Mary's son, so the son of one of the daughters, age 10, brown and healthy. And Alice Addison, Mary's daughter, age 3, brown, healthy. James Addison, Mary's son, 9 months old, brown and healthy. Now, one of interesting, an interesting note that was included within their petition was given in order to explain why the owners had failed to submit their claim for compensation by the deadline. And the excuse was that the Addison family, meaning the enslaved family, had fled to their father, or the father of the two adult daughters, in fear of African colonization. So it reads, they left the city on the 13th of April last, 3 days before the approval of said act, because they feared they would be colonized in Africa. And to avoid that, they went to their father, who is the slave of Harry Cook in Montgomery County, Maryland. And with this, as it goes into that, the valuable information that's given in this from a genealogical perspective is, and also from a historical and social perspective, is from the genealogical perspective first, the name of a person who's described as the father, meaning the two adult daughters, is named, or, well, his slaveholder is named, which is actually the most important piece of information that you need from a genealogical perspective, because, you know, as we explained to those doing genealogical research of ancestors who were enslaved, all of the records that you need are going to be within the records of the slaveholding family. And oftentimes, African-American genealogical researchers have much difficulty, or one of the first hurdles that we need to clear is identifying the name of the last slaveholder, because, you know, with that name, the researcher can then go into those records and follow the paper trail as far back as it goes, you know, following information on sale and so forth. So the name of Harry Cook as the owner of their father is very valuable from that perspective. But also from just a social and historical perspective, I think is very valuable in that it shows that the ideals of family was already evident in this enslaved population. Even though they were enslaved, even though their marriages and family relations had no legal recognition amongst themselves, they had their own idea of family, or their own recognition of family relations. So the adult daughters and the mother, who belonged to the Summerville family, even though the father of these adult daughters lived on another, or belonged to another slaveholding family in nearby Montgomery County, Maryland, they still recognized the familial relationship or the familial bond and the recognition of this person as the father. And they actually fled to him when they feared that they would be deported to Africa, because that was the colonization in Africa was originally considered under the terms of the original DC Emancipation Act. That was an idea considered. Not only compensation for the slaveholders, but that this free population would then be deported and colonized somewhere in Africa, ideally Liberia and so forth. And of course, at this time, this population has been oftentimes in America for generations, and their family and community bonds despite their enslaved status. And those bonds were strong enough for the members of this family to seek refuge with a person who was described as their father, who's also enslaved. Okay. Manumission Papers and Affidavits of Freedom, 1857 and 63. These are basic records just that were used to provide some documentation on the free status, again, of enslaved persons who were either manumitted or free under the terms of the DC Emancipation Act later. So here's one of James Theodore Butler. It's just a basic description, Affidavit of Freedom, Manumission filed June 31st, 1857. And within this particular document, it states, on this 29th day of June, 1857, before me, a justice of the peace, personally came Letty Thompson, who is well known to me as a credible person, and makes an oath on the holy evangelist of Almighty God that she is well acquainted with James T. Butler, a black man about 22 years of age, and that she knows him to be free and born of free parents. So actually in this case, this is a free black who's just going to the circuit court to get some type of documentation certifying his status. But again, because even the free population without some type of free papers on his or her person, they could be very vulnerable. They could potentially be jailed or even sold into slavery. So they had a major incentive to get some type of documentation proving their status. Okay. Another example, George Ball. On this particular record, Richard S. Cox is listed as the owner. George Ball is the one who's been manumitted, and this was filed the 1st of December, 1859. And some excerpts from a description of this case. It states, I, Richard S. Cox, did on the 6th day of April, 1853, purchase of Mrs. Elizabeth H. Newman, a manslave named George Ball, whereas it was expressly agreed and understood as one of the terms of said sale and purchase that George Ball should be allowed to purchase his freedom at the price given for him to said Mrs. Newman at $500. And whereas the said George Ball has duly paid to me $500, and is at the time of healthy constitution and sound in mind and body, capable of labor to procure for himself sufficient food and raiment, and is under the age of 45, being about 39 years old, and I being willing and desirous of said execution of the above agreement, set free and manumit the said George Ball. So in this case, George Ball has actually purchased his own freedom. Again, oftentimes the situation that's not well known in the general public is that many of these enslaved persons are skilled workers, and in certain regions, especially outside of the Cotton Belt, but even in some cases there, it was a common practice for skilled enslaved workers to be hired out. And they would get a portion of their earnings. And if they saved their earnings, they could purchase their freedom if they could arrange some type of agreement with the slaveholder. Here's another interesting case in which a free black purchased, initially he purchased his enslaved family, meaning his family was enslaved, although he was free, and then after purchasing his enslaved family, he manumitted them. So here's the actual deed of manumission. To all whom it may concern, be it known that I, Thomas Summerville, do hereby release from slavery, liberate, manumit, and set free my wife Maria, being of age 34 years and able to work and gain a sufficient livelihood and maintenance. I do declare her discharged from all manner of service or servitude to me, my executors, or administrators forever. Okay. Within his document, he has his proof of ownership, and this describes the initial purchase of his family. I, Mary Watts, know all men that I, Mary Watts of St. Mary's County, Maryland, for the sum of $700 current money paid by Thomas Summerville, FB, standing for Free Black, do grant, bargain, and sell unto him Maria, age 26 years, one Negro child named Sarah Ann, age 6, one Negro child, Thomas Randolph, age 3, and one other child, Mary Ellen, 1 years old, on 26th of December, 1849. Okay. And one question that we get as far as the manumission is sometimes there's a gap in the time. For instance, in this case, Thomas Summerville, we have the record of him purchasing his family, but when you look at the time of his manumitting his family, there's a gap. When he originally purchased his wife, she was 26 years old, and at the time of her manumission, she was 34 years old. And there were practical reasons for that. Sometime in some states, there were fees. There were fees required for some of this, and also the family was often remained in that status in order to protect them from further vulnerability. Okay. Alfred Pope's Affidavit of Freedom. And what I'm going to do from this point is kind of include some other records that you can find here within the National Archives that you can use to supplement some of these circuit court records and some of these records from the Board of Commissioners, showing how through various federal records you can, based on clues you get from one type of record, you can go to other records in order to construct a paper trail that you can follow. And then after you exhaust various federal records, you can try to go into some local records if you're investigating individuals from a genealogical perspective or just you're a historian doing some type of scholarly research. So in Alfred Pope's Affidavit of Freedom, it states by Colonel Carter's will, Alfred was set free, and now with my consent as executor, in enjoyment of his freedom. Alfred caused this necessary certificate of his freedom to be entered on record in your office and had in his possession a certified copy. About a week ago, his dwelling house took fire in the night and it was destroyed with all of his furniture. Basically stating that his affidavit of freedom was destroyed in a fire, and now he's just getting an updated official record of it. Alfred wishes to leave the district in search of employment and wants to obtain a copy from the record of the evidence of his being a freed man. I would accompany him to your office to offer in person my testimony in the aforegoing facts, but I am very unwell and unable to do so. Will you be so kind as to render him the service he needs by giving him the renewed evidence of his freedom in paper form? Very respectfully, John Marbury. Okay. Now, we have these records on Alfred Pope from the Circuit Court, the DC Circuit Court records that we're featuring, but just to see if we could trace him in some of the other records that we have here at the National Archives, I looked into some of these records to see if I could find other documentation. And we succeeded in doing so. Here we have Alfred Pope and Hannah Cole's marriage record from the Freedmen's Bureau. Now, Freedmen's Bureau records is one of the very useful records that we have here at the National Archives. The Freedmen's Bureau was an organization that was instituted after the Civil War. It was initially a branch of the Army that kind of served the needs of what were termed the contraband initially, meaning the escaped former slaves who were following Union troops. But upon the conclusion of the Civil War, the agency was established for a few years to administer to their the needs of this newly freed population throughout many of the states of, not only the states of the former Confederacy, but states with populations of recently freed African Americans. They administered some of the early, or legalized for the first time, many of the marriage records of these African Americans, those who had considered themselves married under slavery, even though it wasn't recognized legally. Through the Freedmen's Bureau, they could have their marriages recognized for the first time officially. So here's an example of those types of records from here in Washington, D.C. So the same Alfred Pope that the former record referred to as the individual getting his Affidavit of Freedom updated, here within the Freedmen's Bureau marriage records for D.C., we have the documentation of his the official recognition of his marriage to a Hannah Cole. Okay. Freedman's bank records, another record, or another type of federal record that we have here at the National Archives. Here's the same Alfred Pope opening up an account in the Freedman's Bank. This is a record from January 25th, 1870. He's actually making this, opening this account as part of a committee for Mount Zion Church in Georgetown. A draft signed by 3 of the banking committee accompanied with the passbook will always be payable. The banking committee consisted of Edgar Murphy, Barton Fisher, Alfred Pope, and John H. Williams. But John H. Williams is crossed out at the bottom of this Freedman's Bank account record. No explanation is given. But again, Freedman's Bank was an institution that was established to initially with the idea of providing some type of financial banking service initially for the U.S. colored troops and then for the recently freed slave population. But as anyone knows from the history of this, the bank fell, and many of the individuals who opened up accounts in this institution lost a portion of their money. Okay, but from a genealogical and historical perspective, these records are valuable in that it does give some documentation of individuals who were recently or formerly enslaved. Hannah Pope, again, who's the wife of Alfred Pope, the former Hannah Cole, also had her own account within the Freedman's Bank. Here's her record from August 18, 1871. It gives her residence as Frederick Street in Georgetown. Occupation, it only has she lives at a shop. Children, it has Catherine, and her mother is listed as Barbara Williams on her particular Freedman's Bank account. And there's a third account associated with this family, another account from Alfred Pope, August 18, 1871. It simply gives his residence as Georgetown, D.C., occupation night scavenger, and has his wife on his account, Hannah Pope. Okay. Of course, here at the National Archives, we also have all of the old census records from, all census records prior to 1940. Okay. Here's the family within the 1870 U.S. federal census. The 1870 census is very important in that it's the first census that's going to count all African Americans, meaning those who were formerly enslaved. Of course, this is going to be the first census after the Civil War and after the emancipation of all enslaved Americans. Prior to 1870, if an African American was enslaved, he or she would not be counted in the census other than numerically notated in what were called slave schedules, meaning their names aren't given, no description of them is given. It's just a supplementary type of census that's attached to the census records of slaveholders, meaning it would numerically document the amount of slaves that the slaveholder had and give a general notation of the gender and ages of these persons, but no detailed information in regards to names were given. So they're not really valuable for genealogical research in depth, but it can provide some clues if you have an ancestor who was around a certain age at a particular time and was owned by a particular slaveholding family and so forth. So 1870 is the first census in which the Pope family as a whole is going to be counted. And here's good information provided in this particular census for the family. Alfred Pope is listed as age 46, described as a common laborer. Hannah is 40, keeping house. Catherine, who was mentioned in one of the Freedmen's Bank records, is age 20 and is now teaching school. Rachel, age 18, is teaching school. Alice, 16, at home going to school. Barbara, age 13, at home going to school. And there's a William, 7, John, age 7, and Emma, age 1. Okay. The family in the 1880 census. Okay. Alfred is listed as at age 56 during this census. He says he keeps a wood yard. Hannah is listed as age 51, keeping house. Rachel, age 28 within the household, is a dressmaker. Barbara, age 23, a school teacher. Alfred Jr., age 20, works at a wood yard. John, age 14, is at school. Emma, 11, is at school. And Lulu, age 8, at school. Okay. Example of some more of these types of records from Washington, D.C. Here are more examples of Freedmen's Bureau marriage records. Here's a Rube Pennell and Eliza Henderson, who I initially found within the Freedmen's Bureau marriage records and went through other records to see if I could trace this particular family. So Rube Pennell, within his Freedman's Bank account record, his name is listed as Reuben Pennell. And the interesting thing about this particular person that I tracked, it seems in each record that I find on him, there's going to be a different variation on his first name. So initially, it's Rube Pennell, and his Freedman's Bank account is Reuben Pennell. This is from August 24, 1867. The valuable information given in this, again, from a genealogical perspective, is the names of his former slaveholders that he gives. His master is listed as Martin Stalter, and his mistress as simply Betsy. His physical description given in his Freedman's Bank account, he's described as 5'4", light brown. He has children, a Benjamin Pennell. His place of birth was King William County, Virginia, and his residence at the time that he opened this account was 18th Street between L and M here in Washington, D.C. Okay. He has another Freedman's Bank account later in 1873, Reuben Pennell, Freedman's Bank account, 14th of August, 1873, listed as age 62, listed simply as dark. His residence still at 18th Street between L and M. Occupation is laborer, and his wife is Eliza Pennell, the same Eliza, I think it was Henderson, as described on the Freedmen's Bureau marriage record. And again, from the federal census, Reuben Pennell, age 67, huckster, born in Virginia. Eliza Pennell, age 35, wife, keeping house, born in Virginia. And Mary E. Pennell, their daughter, born in D.C. One caveat, and one thing to keep in mind in regards to all of these records, census records especially, is that you will often find discrepancies in these records as far as ages, spellings, and so forth. So we try to emphasize that to researchers who sometimes approach these records with the idea that everything is going to be completely correct with no mistakes, but the mistakes in the records as far as spelling, ages, misprints, and so forth are very common. But use the census records or any of these records as just one piece of a larger puzzle, where you try to gather all of this information and compile it, put it together in order to form a larger picture as far as, based on all of the various types of evidence that are provided within the records. Okay. Now, fugitive slave case papers and habeas corpus records are also within the U.S. Circuit Court records, and these are very important. Again, during the period of, especially during the Civil War, there's going to be an issue of fugitive contraband, meaning escaped slaves who were following Union troops or using the commotion and the turmoil of the Civil War as, the chance to escape and to try to gain their freedom. And even prior to the Civil War, there were instances in which many individuals had fled and escaped, and records of these incidents are often documented within the DC Circuit Court records. Here's an example of that. This is a fugitive slave claim involving Mary Massey, who's the owner, and a Mary Ann Williams, who's the fugitive. Okay. Here's a warrant for arrest, the fugitive, Mary Ann Williams. Whereas Mary Massey of Alexandria, Virginia, has applied to the Circuit Court for the rendition to her of a certain black Negro woman named Mary Ann Williams, you are hereby commanded forth to arrest her, she being found in your bailiwick, and her safety keep, so that you have her body before the Circuit Court of the District of Columbia immediately. So Mary Ann Williams was actually arrested, and she was captured and returned to Mary Massey. The said Mary Massey, having produced in open court the record hereto annexed, and the said Mary Ann Williams being brought into court by the marshal on a warrant issued by the court in these premises, her identity having been proved by Rudolph Massey, it is thus ordered that the marshal deliver here the said Mary A. Williams to the said Mary Massey, and Mary Massey is authorized to transfer Mary A. Williams to the state of Virginia from where she escaped. Okay. And similar to just the typical fugitive slave records are the habeas corpus case records of the U.S. Circuit Court for the District of Columbia. These range from 1820 to 1863. They include petitions for writs of habeas corpus, manumission papers, statements of freedom, and other documents related to the proceeding of accused runaways. Okay. And here is one example. Habeas corpus petition of Emeline Brown from March 22, 1862. Emeline Brown, a free colored woman, and the next friend of her daughter, Lucy Brown, respectfully represents that her daughter, Lucy, age 12, is unjustly and illegally detained and held in custody by one Benjamin F. Hunt of Georgetown. She is held and detained against her will without any authority of law. Your petitioner is informed that a year or two ago, her husband, John Brown, the father of said Lucy, and slave for life belonging to Richard Pettit, Esquire of Georgetown, hired the said Lucy to Mr. Hunt, but that she believes Lucy is maltreated by said Hunt and that she desires said child. Okay. And here's the habeas corpus petition of the person alluded to in the other document, the father of Lucy. The petition of John Brown, a free man of color at this time, this is late October 1862. The petition of John Brown, a free man of color of Georgetown, respectfully shows to your honors that his child, Lucy Brown, an infant of about 11 years, is unlawfully detained and restrained of her liberty by one Benjamin F. Hunt of Georgetown, and that Lucy has not been bound out or indentured to said Hunt, who is in no wise entitled to detain her, but that your petitioner is the natural guardian and protector of said child. Okay. And in this particular case, Lucy is ordered back into the custody of her father, John Brown, on November 10th, 1862. In the above entitled cause, it is this 10th day of November, 1862 AD, ordered by the court that the said Lucy Brown be remanded to the custody and control of her father, the said John Brown, and the said Benjamin F. Hunt no longer detain or restrain her. Okay. Another case is the one of Basil Barnes. Elizabeth Conti respectfully represents that she is a free colored woman residing in Washington, D.C., and that she is the nearest legal relative of her brother, a colored boy about 7 years old, named Basil Barnes. Basil has been fed and nourished by her, and all his wants provided for to the 28th of July last, when one William A. Malloy came to her residence and forcibly took from the premises Basil to some place unknown to your petitioner. Thank you. It continues. Your petitioner further represents that the child Basil is himself free and was born of a free woman, that his mother, is now dead and was dead long previous to the act complained of, that the father of the said child is a slave owned by a Mrs. Lyell or Lyells, residing in the neighborhood of Georgetown, and his name John Holliday, and was never married to the mother of Basil. Your petitioner offers the testimony of Oswald B. Clark, a white man who saw said Malloy take the child. She also tenders her own free papers and those of Rachel Barnes, her mother, and who was also the mother of Basil. So this is a case of a freeborn African-American child who has been, the petitioner says that he was forcibly taken or detained by another person, or this person referred to within this particular case. Okay. Oswald B. Clark, the person described as the white man who's vouching for this particular case, he declares, Oswald B. Clark declared that he saw William A. Malloy on the afternoon of Friday, July last, take from the yard of Elizabeth Conti a free colored woman, a colored boy aged 7 or 8 years. Said Malloy was on horseback accompanied by a man on foot. Said Malloy placed the boy on the horse behind him. The boy was evidently taken off forcibly. Said deponent further declares that the boy was taken in spite of the entreaties and protestations of said Conti. Okay. And unfortunately, in this particular case, within the records, there's no information given on the final outcome of the particular case. Another one, Robert Nelson, habeas corpus petition against Alfred Jones. Okay. And this is a case that involves all free persons of color. Okay. The petitioner, Robert Nelson, a free boy of color, is now held and confined in the possession of one Alfred Jones, a free man of color. Alfred Jones claims the right by virtue of deed of indenture executed by Nelson's mother, Patsy Nelson, now deceased. Of said indenture, your petitioner alleges it is defective, having been executed while the orphan's court was in session, and had never been filed among the records of the orphan's court. Okay. He further alleges that Alfred Jones has treated him with harshness and cruelty, often beating him, cuffing him in the most cruel and proper manner, that he has failed to supply him with proper food and clothing. That he has failed to supply him with proper food and clothing, that he fails to send him to school and to church, and to teach him a trade, and that he has failed in all respects to give him proper training or to make proper provisions for him. Again, in this particular case, no final outcome is given. Here's a case of a Granville Williams who is detained in Washington, D.C. Okay. Dear sir, I have just received your note and hasten to inform you that the boy, Granville Williams, is free, referring to a free person of color. He is the son of Solomon Williams, who formerly resided here but left several years ago with a view of going to Liberia. As it was understood, this boy was at the time an indentured apprentice to Mr. Floyd Smith, and several of us endeavored to procure his release by Mr. Smith, who refused to let him off in fear that he might accompany his father and family to Liberia. Mr. Smith was a tanner, and having sold out, transferred the remainder of his time to Mr. George Keister of Blacksburg. His whole story is correct, and if I thought there would be any doubt about his release, I would furnish any amount of testimony in favor of his freedom. Again, this is a case in which a free person of color, is detained in Washington, D.C. after being accused of being an escaped or a runaway. Again, highlighting the state of vulnerability that even free blacks, the state of vulnerability that characterized their lives, despite their official free status. Okay. In this particular case, there is a final outcome within the records on July 25th, 1855. Upon an examination of this case, I am satisfied that Granville Williams is a free man and do order him to be discharged from your custody. Okay. So that's the final case that I have within the records, but I want to go over one more case that I forgot to include within the presentation. And any of you if you have access to our website, you can always go online and read our prologue journal. It has many articles involving genealogical research. And if you go online, you can click under subheadings or subtopics of genealogical articles, and it goes to various topics such as articles associated with African Americans, Native Americans, any topic involving genealogical research, and it will take you to all of the articles under those subheadings or subtopics. But another case, again, I failed to include within the presentation, but again, just highlighting the precarious status or the vulnerable status of even free blacks is the case of Patton Harris. Okay, in his particular case, Patton Harris, a free black who was arrested twice and jailed as a runaway slave while traveling by train from Virginia to Ohio. Well, he was jailed here in Washington, D.C. That's, of course, and that's why his records appeared in the D.C. Circuit Court. He was first arrested while passing through Richmond, Virginia, and again while passing through Washington, D.C. In Washington, Harris spent nearly a year in jail. His petition for habeas corpus states, Patton Harris respectfully represents to your honors that he has been for the last 11 months and is now illegally held in confinement in the jail of Washington County as a runaway slave. Edward H. Mosley, the executor of Harris's former owner, eventually sent a detailed letter to the court verifying that Patton was indeed free. And in doing so, he revealed much information concerning his family history, or Patton's family history. And Edward Mosley's letter reads, I was the executor of Anne H.W. Harris, who died in 1832, and by will directed that after all her just debts were paid, her slaves should be liberated. I succeeded by keeping together and hiring them out for several years and paying off all her debts, and 4 or 5 years ago, in setting them all free. This boy Patton went off with the rest, and until last spring, I supposed he was in Ohio. But sometime in April, I received a note from him informing me he was confined in jail in Richmond. I immediately went down and had him set at liberty, carried him to the railroad depot, and put him in the care of one of the clerks to be sent on to Washington the next morning. I paid his passage and gave him some money to pay his expenses on the way. I also gave him a deed of manumission. I believe I had the certificate of General Lambert, the mayor of Richmond, attached to it. Edwin Clark, a clerk on the Richmond and Petersburg Railroad, gave him certificates to travel through Washington without interruption. Now, if he has preserved these, the proof will be irresistible that he is the same boy and will, I think, be set at liberty at once. But to test his identity, ask him the names of his fellow servants set free by his mistress. There was Tom, Stephen, Davy, Ned, I believe, who was Patton's brother, Anthony, Betty, I believe the mother of Patton, Ned, and Matilda, and Jenny. I do not recollect any marks that Patton has. He is about 25 or 6 years old, complexion is black, and about 5 feet 8 or 9 inches high. In this particular case, Patton Harris was set free in May of 1843 after being arrested in June of 1842. So again, just highlighting the precarious nature. He spent nearly a year in jail, and for a long time, the executor of his former owner assumed that he was living free in Ohio, but he was arrested just a short passage from Richmond, arrested first in Richmond and then again here in Washington, D.C., despite having, more than enough documents to prove his free status. Again, highlighting that very precarious state in which even free blacks existed in at that time. So the records that I've gone over today are various records associated with slavery and emancipation here in Washington, D.C. Even though they focus primarily on the District of Columbia itself, as you can see, many of the records relate to surrounding areas of Maryland and Virginia. So if you have ancestors within this area, including Maryland and Virginia, these records can potentially be valuable. And if you're just a scholar who's interested in this aspect of American history, these records can also be very valuable. I'd like to open up the floor for any questions or any comments.
While we're waiting for people to queue up to the microphones. Looks like we have one gentleman.
I always hate it when somebody gets up to ask a question. It's not a question. So when I get through with this little remark, just put a question mark at the end. Something I never was told at school, many of the prominent New England abolitionists voted against this emancipation, DC Emancipation law, because they felt that no man's existence could be put a price upon.
Okay. I'm not well versed on those records, but thinking of the record or the terms of the act itself, the compensation was a major aspect of it. And again, it was just the political reality of the time. The President Lincoln at the time was kind of navigating and working his way towards what eventually became the Emancipation Proclamation. But even during this early period, as he's deliberating how he's going to approach this reality, the idea of compensation was a major component originally, and even going towards the Emancipation Proclamation, I think, prior, as he was deliberating and I guess weighing different, some of the practical strategies in which to proceed. The compensation, even on a larger level was a major idea, along with colonization originally. The idea of recolonizing this free population overseas somewhere, whether in Africa or Central America or the Caribbean and so forth. But those were initially two major aspects, the idea of compensating former slaveholders and then colonizing the population elsewhere. And both aspects of both of those ideas received a lot of opposition from from free African Americans and abolitionists. So,
That lady was before me.
oh, sorry.
Hi, Damani. You mentioned that some enslaved people, such as the one who had been owned by Robert E. Lee, petitioned for themselves. My question is, how would they have known that their owner had not filed a petition? Was there some kind of public notice, or?
Well, in the case of Robert Lee, to file a petition, you had to prove or try to prove that you had remained loyal to the Union. So in the case of Robert Lee, that was obviously not the case. And also, much of the information, at this time, under the terms of the Supplemental Act, July 12th, meaning if an enslaved person was residing in Washington, D.C., meaning the person was working and hired out, but that was the person's place of residence at the time, the person could file for freedom or for his own free status and so forth. So I think his name was Robert Meredith, the one who claimed to be, enslaved by Robert Lee officially. I mean, he would have known the terms of the particular act. He knew that he had resided in Washington, D.C. at that point for years, probably just working as a laborer. He was one of many enslaved persons who were originally owned, I guess, by Robert Lee. But just his own knowledge of the terms of the act, I think he had an incentive to submit a petition for freedom just to get that done, just to have some proof that he was someone who qualified for freedom under the terms of the act. I mean, and if he could get it, I guess he would feel a little more secure that, meaning he would not, with no type of, no way of knowing the future and what's going to happen. He might have feared that if he remained officially listed as an enslaved person, he could risk being sold elsewhere or whatever. And if he could get his freedom, he could try to, just move or go somewhere else and not worry about being considered a fugitive. Just have freedom of movement.
Right.
But all of that is speculation, though.
Right. And to your knowledge, though, there were other enslaved people who filed petitions for their freedom?
Yes, there were enslaved persons. I think the actual number, under the terms of the Supplemental Act, there were 161 individuals who submitted claims under that term, meaning these were individuals whose owners or no one had come forth to submit a claim for compensation in regards to their freedom. No one had come under the terms of the original act, even though they resided in Washington, D.C. So with that, they could now, under the terms of the Supplemental Act, they could, go to the circuit court, provide some type of proof, including witnesses or whatever, verifying that they had resided in Washington, D.C. for years, or that they resided in Washington, they were residing in Washington, D.C. at the time that the act was passed. And if the person could prove that, he or she could then get freedom, get their freedom, regardless of whether any slave owner had pursued it originally.
Thank you.
Yeah.
Yeah.
Okay.
Yes. I'm work for a prison reform organization, and there's a lot of movement toward prison reform today, bipartisan. And there is becoming from the grassroots a movement to repeal the exception clause in the 13th Amendment, which says slaves are free except for those that are convicted of crimes. I noticed that this also has the except for crime in the first paragraph. And from my research, it seems like it comes from the Northwest Ordinance that Jefferson basically wrote and included that exception clause in it. I was just curious in your research, and I guess, too, on these individual cases, how did they determine, if somebody said, I'm crime-free, I mean, what was, how did they prove it? How did they, but basically, this has been something that is, I mean, we still basically accept slavery in our Constitution because we have, except for those convicted of crime, they're still considered slaves. So we have that, but also on the individual cases of this 1862 Act, how did you determine, how would somebody determine that, whether they're...
Well, I don't know for sure, but I assume, in going through the records, I assume that as long as nothing came up indicating that the person, or no one subsequently accused the person of engaging in some type of criminal activity, everything was clear from that point. Initially, the person could just submit the petition, and this is really going, I guess, towards the Supplemental Act, when many formerly enslaved persons who were deemed slaves but residing in Washington, D.C., once they went, I mean, of course, they're not going to, if the person had engaged in any crimes, they're not going to admit that. And so, they would just provide evidence and proof to verify that, they lived in Washington, D.C. at that time, were working or hired out here in Washington, D.C. And I assume as long as no one subsequently approached the circuit court or no information came up indicating that this person had committed any crimes or engaged in any type of criminal activity, I mean, everything was just smooth sailing.
Yeah, and there were some cases that you talked about of people incarcerated.
Oh, yes, so those were cases of fugitive slaves.
Yes,
These were individuals who were enslaved and who escaped.
And that was considered a crime, though.
Yeah, that was a crime. That's why I think Mary Williams, the enslaved person,
So they would
the
have to
owner
prove-
and the enslaved
It's just-
person were named Mary. I can't recall
Yeah. And
the names, but yes, it was a crime. It was a crime to escape, a crime to run away. That's why escaped slaves would then be arrested and jailed and detained until, the slave
they'd
holders
still
would
be a
come.
slave. no
Yes,
matter-
they were
yeah,
still
under this.
enslaved.
Yeah.
And those were individuals who were legally and actually, they were enslaved. That was their status. But, kind of going towards your point, the reality was that even blacks at the time who had every document and every affidavit of freedom and were born free and so forth, the presumption was still that, they were slaves or they were still vulnerable to incarceration. We saw multiple cases of that, which are just, just the ones that I just happened to come across within the records. So it was the main, regardless of the status of the black population, the idea was that enslavement was the normal condition, and in being detained was just a reality of life, regardless of status. So free blacks were just as vulnerable to this as blacks that were legally enslaved. So I think the Patton Harris case was one in which he was incarcerated in Washington, D.C. for a year, despite, evidently having documentation proving his freedom. And the worst case scenario would be, being incarcerated for a while and then potentially being sold, and which would make it even more difficult to get freedom, or being sold to another region or another state, so that was the reality at the time, based on the records.
In the body of records that you have researched on Washington, D.C., Are there many cases of newly freed people who had the last name of their last slave owner? That's my first question. And my second question is, when you told the story of the Summerville family, of the man who purchased his family, could you clarify why there was that lag in their manumission?
Let me try to, well, going to your first question first. The surnames vary. Prior to going through our records here at the National Archives, you know, the idea that I originally had, and that was common amongst many of my peers, was that the surname of an African American was the name of whoever owned them. But in going through these records, not just the DC records, but Freedmen's Bureau records and other records, that's often not the case. It varies. Sometimes it's the case, but not all the time. It's not something that is 100%. People took surnames based on various reasons. And then you have the issue where people are being sold. So one previous owner might have a surname, then the subsequent owners had different surnames. So which surname does the person take, the surname of the last owner or original owner or what? But there's evidence that some didn't, some just took the surname of someone who they admired, who was not an owner. There were siblings who chose different surnames, which makes it even more complicated for those doing genealogical research. So it varies. You know, there was often the case in which, you know, if slaves were born in a particular family and they remained in that family, and there was a long history of, you know, the slaves being attached or associated with a particular family, in that case they would often take the surname of that family. You know, especially if after slavery they remained in that area for a little while, you know, they would adopt that surname. But there are enough cases and other instances where slaves just had a surname that was not the surname of the owner. I think we saw that in some of the Freedmen's bank records, where the surname was different from the previous owners. So that's something that, so the whole stereotype or the idea that your surname, if you're an African American, your surname is going to be the surname of whoever your slaveholding family, well, that's not the truth. Some pick the surnames of famous individuals or individuals they admired or someone who helped them at some point, you know, all types of various reasons, you know. So the issue of the gap that sometimes existed between a free black purchasing family and then submitting the manumission, you know, the official manumission. I might slip up on this. There was a clear reason that I came across on why that happened. For some reason, it's slipping my mind right now. But in the larger cases, just trying to recollect some other instances of that. One was a case in which certain states and certain jurisdictions made it difficult for blacks to get freedom, or they had an incentive to prevent African Americans from getting freedom. Some states within the history of many of these states, there was a resistance to the population of free blacks because they were perceived as a threat. You know, so within the structure of the court system itself, as far as fees that were established, there were impediments that were instituted, and I can't think of the exact, and I would potentially have to get back to you with that. But in a nutshell, in general, many of the southern states were resistant, or there was opposition to the idea of having a large population of free blacks, you know. That's why during this period, the movement for colonization is happening. The idea of recolonizing African Americans to Liberia at one point is occurring. The idea of a population of free blacks existing in certain areas was perceived as a threat, or a free black population would motivate the enslaved population to also try to achieve the status. Or there were certain reasons, and the process of getting that free status was kind of made difficult sometimes. I know what I've told you right now isn't the more concise answer, so I will have to get back to you with it, because the details of it are slipping my mind right now. But there was a clear reason that it sometimes took this time period for it to occur. Also, in certain, at a given time, if I recall correctly, there were some statutes in areas in which newly freed blacks were kind of pressured to leave and to relocate. And there were certain laws in regards to that. And in order to try to stall that, the family or the free black who purchased his family would just keep them in a slave status, because within that slave status, they were actually more secure than having an official free status. You know, again, kind of highlighting the precarious state of existence for even free blacks, the smaller population of free blacks at this time. But once I get the clear explanation for it, I'll forward that to you. Mm-hmm.
Thank you so much, Damani. I want to thank everybody who has come to us today. If you watched online, we also had C-SPAN join us today. Thank you to that audience for joining us. Of course, to our in-house audience. Obviously, we could go on for a while, and I hope, Damani, that this encourages you to come back and do another presentation for us in the future. And if we didn't get to your question, you can submit it to our email address, inquire@nara.gov. Again, inquire@nara.gov. And I also want to do a quick plug for the virtual genealogy fair. That's October 26th and 27th. Thank you so much for joining us today.